Bienvenidos a la Universidad de Boston, la Escuela de Leyes. I am going to try to speak a little bit slowly, just because I don't know all of your level of English, but please stop me if you want to ask any question or need a clarification. So I'm very happy to be with you today. And I was just saying to Hector that I would love to be in Mexico right now because it's been snowing in Boston and the weather is very cold. So you all are very lucky from my point of view. So let me introduce my work a little bit. Shall I start with that? And the clinic. I am the director of the International Human Rights Clinic at Boston University. And I know that there are some quite big differences between legal education in Mexico and in the United States. And clinical programs are one of the differences. I think very few law schools in Mexico have the equivalent of our clinical programs. So I'll just tell you a little bit about what the idea is behind law school clinics. They are intended to expose law students to the actual practice of law before they become lawyers. So most clinics are what we call live client clinics. So students are working with actual clients under, of course, the supervision of licensed faculty practitioners. So we teach students practicing skills like interviewing, legal counseling, negotiation. I teach something we call cross-cultural lawyering, that is best practices in how to be a lawyer in the international and cross-cultural context. And so my clinic is a full year clinic. My poor students are with me for a full year, but it means that we can do very significant projects. I have done a clinic in which we do mostly individual case representation, but the clinic that I am directing now works on major projects around the world with international partners, and we are mostly focused on policy changes, trying to pressure states to change laws, and working in the United Nations human rights system, and in the regional systems, mostly in the inter-American system. So you can ask me questions about all of that. Another difference, I think, a big difference between Mexican law school and US law school is that most Mexican law schools are undergraduate programs. And in the United States, law school is a graduate program. In addition, many of our students who come to law school these days have had work experience already before they apply to law school. So with that background, I'll talk a little bit about our work in Central America. I've actually been working on issues in Central America since the 1980s. I began my practice working with Central American refugees from the crises of the civil wars in El Salvador and Guatemala. And I ran a program in California where we were representing many of the hundreds of thousands of Central American refugees who were coming to the United States at that time. So I began my career in this area, really on the work on Central American refugees. And I've continued collaborations with partners, legal organizations, and NGOs in Central America ever since. Our work in the clinic is all about forced migration. So all of our work relates to refugees, migrants, migrant workers, and also issues of nationality and statelessness. So we are working on various projects around the world with partners in all of those areas. So stop me anytime you have questions, because when you turn my key about forced migration, I can talk forever. So do stop me if you need any clarifications. So I'd like to talk a little bit about the most recent work we've been doing on and in Central America and Mexico, which is a project we have finished the major phase of this project. It has been a 5-year research and fieldwork project on the disappearances of migrants from Central America. And the work took us to Mexico, El Salvador, Guatemala, and Honduras. And we met with families of the disappeared. We met with governments and non-governmental organizations, with migrant shelters, with church groups working with migrants all across the region. We interviewed them, we did a lot of background research, and we've just completed the report, which focuses on the laws and policies affecting migrants who disappear, most of them coming from the area of the Northern Triangle. And I'm very pleased that UNAM is now in the process of helping us with translating that report, which is something like 300 pages. So only the most dedicated will read it. But we hope that it will be published simultaneously in English and in Spanish in the very near future, so that this work is accessible to our partners and families across the region. So our main partners, they've been amazing to work with, are the Fundación para la Justicia y el Estado Democrático de Derecho, FJEDD, which has offices in Mexico and in all of the countries of the Northern Triangle, and another organization that worked closely with us on fieldwork, the Peace Brigades International. So I'm sure that you are all aware of this, but just to give you an idea of the scope of the problem, within this past decade alone, in Mexico, Honduras, Guatemala, and El Salvador, and the United States combined, somewhere between 75,000 and 120,000 migrants have disappeared. And of course, I say somewhere between because the exact number is not known, because there isn't a reliable database in the region. And our work has been to highlight that the crisis, because it involves all of the states of the region, so the solution has to be transnational. And the point of the report is to hear from the families about what they are demanding and how they want such a transnational solution to work. So our report has 4 themes for the recommendations, and they're all based on what the families have told us. And the themes aim at solutions both at the national and at the transnational level. So the first theme is the need for a more effective state response to investigate all disappearances. The second theme addresses the particular type of disappearances called enforced disappearances. That is, disappearances in which it is state action or state lack of action or complicity that allows those disappearances to happen, where the state is somehow involved in the disappearance itself. And that theme calls on all states to conduct prompt and effective prosecutions of those actors, state or non-state actors, to prosecute them and hold them responsible as a way to signal that future actors, perpetrators of these crimes, will not be tolerated by the state. The third theme is the need for proper, yeah? Sorry, was there a question? Okay. The third theme emphasizes the need for proper procedures for identifying and for repatriating the remains of people who have been found, whose remains have been found. And finally, the last theme calls on all the states to provide adequate reparation to victims of disappearances, including the families themselves. So what we have been trying to set out is the legal foundation for all of these demands. And under international and regional law, Mexico and the Northern Triangle countries have certain basic common obligations to respond effectively to migrant disappearances. And these include conducting prompt and thorough investigations, prosecuting perpetrators, and identifying and respectfully repatriating remains. And this last one is important. Yeah, sorry?
I think it was like a micro that was open, but that's okay.
Okay. And please feel free to include in the chat if you have questions that I'm missing or comments that I'm missing, and I'll try to follow those as well. So in terms of the last aspect of this, which is respectfully repatriating remains, we heard from so many families that without their consent, they would receive the ashes of their loved ones from governments, and they, because of distrust with governments, didn't really know whether that was really their loved one or not. And returning ashes prevents them from giving a respectful or a Catholic burial or a burial in line with their own faith traditions. So that was deeply a concern that was deeply felt by many families. Other related criticisms from the families were that sometimes they received bones, and the bones were not the bones of their loved one. So this complete disconnect between what states believe that they are doing in returning remains and what families feel that they are actually receiving. Very, very critical piece of the concern in this whole process. Another problem that we found in this work was that there are various uses of terms that apply to people who have disappeared or are missing. International law has very specific definitions for some terms, but not for others. And national laws across the region do not have uniform definitions of when a person has disappeared, as opposed to someone who is missing, or for example, another common term, no localizado. Along the migratory route, migrants are subjected to what are variously termed forcible disappearances, enforced disappearances, non-forcible or non-enforced disappearances. And depending on which definition applies, states believe they have more or less obligations. But international law has some very specific definitions. That is, forcible disappearances, which is when private non-state actors cause the disappearance and the government is not involved, while enforced disappearances occur when governments are responsible for or take part in or knowingly allow the disappearance to occur. In contrast, a non-forcible or a non-enforced disappearance occurs without any human intervention, as when a migrant succumbs to illness during transit or suffers a mishap while traveling through dangerous terrain. And oftentimes, the source of the disappearance is unknown. Also, when a disappearance occurs, there's usually a delay in reporting because family members are not immediately aware of the fact that their loved one has disappeared. So international and domestic laws focus almost entirely on enforced disappearances, but still what we have found is that all 5 states have a duty to take certain steps to treat all forms of disappearances with a certain level of attention and response, even if they are not enforced, that is, even if the state is not involved. Another problem is the lack of common treaty-based obligations for all of the relevant states, that is, the Northern Triangle states, Mexico, and of course, the United States. One of the most important treaties on this problem is an international convention, the International Convention for the Protection of All Persons from Enforced Disappearances. We call it the CPED. And Mexico and Honduras are both parties to this treaty, and therefore they have specific obligations under it. Guatemala is a signatory, but it hasn't ratified the convention. And neither El Salvador nor the United States are parties to this convention. So what we are finding is that although there are some very strong treaty obligations, not all of the states of the region are parties to the same treaties. So finding those common obligations has been part of our challenge. Now, the CPED is particularly strong because it requires state parties to establish mechanisms that effectively respond to disappearances, provide certain guarantees to families' right to truth and justice, and to properly and respectfully handle repatriation of remains, and most important, to fully cooperate with other states to achieve each of these goals. So now one of the demands is that Guatemala, El Salvador, and the United States ratify this treaty so that there are common obligations for all of the states of the region. And the same problem is true of other treaties, including the International Convention on the Protection of the Rights of All Migrant Workers. Again, El Salvador and all of the Northern Triangle countries are parties, but the US and Mexico are not. And the Migrant Workers Convention has some very clear protection for migrants. And again, that is missing because not all of the states are parties. And we are most concerned about the US not being a party to this treaty because more than 2,200 migrant remains have been found in the United States since 2014. And we know that this is not the full number because, again, there's a problem of keeping statistics and identifying the remains as being remains of migrants. And as I'm sure you all know, the United States is the destination for most, if not all, migrants in the region. And from our perspective, US migration policies are a major cause of human rights abuses against migrants, causing thousands to disappear. So another important element in this work has been the factor of the inter-American human rights system in finding the solution. And Mexico and the Northern Triangle countries are all states parties to the American Convention on Human Rights, which also has major protections, but the US is not. And there have been some important developments out of the inter-American system with regard to migrant disappearances, including the most important case, which was the first case out of the Inter-American Court, Velázquez Rodriguez versus Honduras, which establishes for the entire region what is an enforced disappearance and what minimum state obligations there are towards the disappeared and their families. So again, because the US does not participate in the Inter-American human rights system, though it is a party to the Organization of American States, we have a disconnect between the case law and the decisions of the human rights mechanisms of the Inter-American system with regard to the United States. So the findings and conclusions and recommendations in this report highlights these families' demands for truth and justice, and really focuses on how these demands can only be met through a transnational solution. And our main focus is two laws that Mexico has passed, very important laws. The focused on the Mecanismo de Apoyo Exterior Mexicano de Búsqueda y Investigación, what we call the MAE. And this law was passed and the mechanism established in 2015. And it is really a groundbreaking law that is the result of years of work and pressure from the families of the disappeared, including Mexican families of the disappeared. And they are calling for this MAE to be fully established and to be reformed to ensure access to families, not just in Mexico, but across the region, through the Mexican consulates in each of the countries, to ensure full access and investigations, justice for the families, prosecutions, very important data sharing, a joint protocol with the Argentine forensics team for DNA capture and matching DNA with family members across the region, and hopefully also respectful return of remains. And we're focusing on this mechanism as the most effective transnational response that can address this widespread crisis of migrant disappearances. Now let me stop here and first take questions about this, and then I can talk a little bit more about each of the countries' individual laws and some of the main issues that we found in each one. But let me stop and open it up for some discussion.
Hello, my name is Frank. And my question is, you said that you've been in this topic since 1980s. And I want to ask you, how much does the immigration situation has changed since then?
Yes. So in terms of immigration to the United States, of course, we have had both progressive and regressive policies that have affected migration. At the end of the civil wars in the early 1990s, strangely enough, it was the Reagan administration that had the first most important amnesty law that really granted permanent status to thousands of the refugees who had come to the United States. And that was the what we call the January 1, 1981 amnesty provision that allowed legalization for the thousands of refugees who, by the way, under the law at that time, the majority of whom were not able to actually get asylum status. So there was pressure as a result of the Esquipulas agreement across Central America, which ended the conflicts and provided solutions for the refugees that came from this conflict, there was pressure that if the United States sent back all these thousands of refugees, that it would destabilize a very, very delicate peace process. And so the United States passed a very generous law. And we were very happy to work with our clients and get them permanent status. And then there was a subsequent law that allowed the family members to join them and provided both permanent status and then subsequently another form of temporary status for people who later came up as part of family unification. So that was a very progressive period after a very, very regressive period. And then we have seen waves of policies, but I would say the main trajectory or the main way in which the United States has been dealing with the region has been more and more pushing United States migration controls farther and farther south. And when we have interviewed Mexican experts, one of the common themes that they have told us is that all of Mexico has become the United States southern border. And most recently in the Trump administration, we have seen something that has never been in place before, which is the third country agreements, what the US called the ACAs, the asylum, third country and first country of asylum agreements, where the US was trying to place the burden on El Salvador, Honduras, and Guatemala to say that if any migrant or refugee passed through those countries before coming to the United States was not responsible for accepting their asylum claims, but could send them back to any of those countries that they passed through. Now, mercifully, we have just had the Biden administration stop those agreements, stop the implementation of those agreements, but we will see if in another administration, more regressive administration, those kinds of policies will be revived. So one of the most important aspects of working together with our partners across the region is to ensure that the United States becomes part of the inter-American human rights system and becomes subject to the obligation of the minimum protections that the human rights system ensures. And that is, if we are able to achieve that, and by that I mean the US becoming party to the American Convention on Human Rights and agreeing that it is subject to the mechanisms of the human rights system, that then we NGOs and civil society can work together with our partners in Central and South America to hold the United States accountable for its migration policies. That's a very long answer to your question, but thank you for the question.
No, thank you.
Hello, I'm Novia. Well, my question is basically because you talk about that some agreements are about human rights has not been ratified yet. So also you talk about the abuses of human rights that sometimes exist. How is the defense mechanism or exists some defense mechanism of their human rights?
So do you mean defense mechanisms in terms of defending migrants and refugees within the United States?
Yes.
Okay.
Yes. For example, in Mexico, sometimes they're used like the amparo or something like that, but I don't know how it is in the United States.
Yes. Sadly, we don't have the equivalent of amparo in the United States. And if the United States was part of the inter-American system, then the amparo would be available here as well. All of the US migration and refugee law is controlled under a major piece of legislation called the Immigration and Nationality Act, which goes back to 1952, but has been amended many times. And the most important amendment was in 1980, when we ratified the refugee protocol. We had actually ratified the refugee protocol many years before, but it only became incorporated in the Immigration and Nationality Act in 1980. And I was one of the lucky lawyers to be among the first to start working under that law. And I really became a refugee lawyer, learning that law on the backs of the Central American refugees, really. But that law is supposed to incorporate all of the provisions of the Refugee Convention and Protocol. But unfortunately, the US has made some very important changes when it incorporated refugee law into its national law. And there are some major discrepancies between the way the US operates or implements its international refugee obligations and what the international community consensus is about those obligations. So our work is within the US statutory implementation of international refugee law, and that has certain limitations. Some of those limitations we are able to challenge by using the US Constitution, but the US Constitution is not very strong on the rights of migrants and refugees. So there is an enormous civil society response and defense to refugees and migrants all across the United States. We have very, very strong migrant defense organizations, clinical programs like mine. Mine is not unique. Most of the major law schools around the United States have students who are working on migration issues, defending migrants in court. We actually have 2 clinics that are focused on migration and refugees. We have an immigrants' rights clinic where the students are in court representing migrants and refugees all the time, but particularly across the southern and southwest of the United States, there is a strong defense community working on all aspects of this. But we have limitations because of our law. The law itself has limitations. So
Thank you. Thank you very much.
Very good question. Thank you.
Well, hello, I'm Esther. I have a question too. And I want to know, what did you think about the sanctuary cities about the protection that they have for refugees and immigrants?
Sorry, say that again, about the what?
Yes, about the sanctuary cities.
Sanctuary cities, yes.
Yes,
yes. So the Sanctuary City program is also not a new program. It actually started well before the 1980s. And unfortunately, the US government has been quite, not just the federal government, but state and local authorities have been quite aggressive in not protecting the sanctuary city programs. And there have been lawsuits, particularly California and Texas, to prosecute individuals and church groups that have been involved in the sanctuary program. So we have some very bad decisions from the courts, which basically say that sanctuary programs, cities and churches are not operating within the law. And one of the ways in which that has taken place is something, sorry to call it by a technical name, but it's called 287G for the portion of the statute. 287G programs have been a way in which the federal government has tried to force states as an incentive to give states funding for their refugee and immigration programs, to insist that states agree to these 287G contracts, which means that states tell the federal government they will cooperate with immigration authorities at the local level and turn people over to immigration authorities when they find out someone is not documented. And that can be someone going to court, for example, for a family law dispute. It can be someone getting stopped for a traffic violation. So in the past, and traditionally, states have refused to become part of the federal immigration enforcement process, which they shouldn't, because otherwise their communities cannot be kept safe by law enforcement. And there has been an ongoing challenge between the states and the federal government over enforcement of these 287G agreements. And that has been a major pressure on the sanctuary community. Having said that, some states have taken a hands-off approach. Massachusetts has both Cambridge and Somerville are sanctuary cities, and the states have been quite happy to allow sanctuary programs to continue here and for people to be protected in churches and in those communities. But that is not the situation for most of the sanctuary programs around the country.
Okay, thank you.
Okay, if there aren't more questions on this, let me talk a little bit about about the disappearances issues in each of the relevant countries. I'll just talk very briefly about some of the main points. Starting with Mexico, some of you may know that as of 2020, the Mexican government has reported over 70,000 disappearances in the country. And again, that's an estimate. Families and NGOs believe it may even be much higher. Most of the disappearances are reported in two states, Coahuila and Nuevo León. And if you look at the map, you can see why that might be. In 2007, Mexico established the National Commission on Human Rights with the goal of addressing the violation of human rights that is recognized under Mexican law. And the National Commission on Human Rights works with another law that Mexico passed in 2017, a very important law, the General Victims Law, Ley de Víctimas. And Mexico enacted the Ley de Víctimas to define victims of human rights violations and to guarantee them remedies. The law provides very comprehensive support and redress for victims of human rights violations and allows both direct and indirect victims to access the law's remedies. But there are some serious obstacles that have been preventing individuals from benefiting from it, especially migrant families. For example, migrants and their families have problems in obtaining victim status because they cannot travel to Mexico to file an application or to follow through with the procedures. And even more important, there is a lack of cooperation between and among state and federal authorities in Mexico that cause some serious violations, serious obstacles to victims' families. Also, Mexican authorities require migrants to meet a very high standard of proof to establish that an agency or a federal employee was responsible or involved with the disappearance. And often migrant families don't even have enough information to file a report or successfully file a claim. And then other factors like fear of detention, deportation, reprisals, or lack of trust in state authorities are preventing migrants and their families from reporting crimes. The criminalization of migration in Mexico that is really influenced by United States policy has pushed migrants to more and more dangerous routes, both through Mexico and in the United States. And not surprisingly, the remains of Mexican migrants, of migrants in general, are being found in a few states in the most, what we call, hostile terrain. That is the desert, the Sonora Desert, and migrant remains are being found primarily in Texas, Arizona, certain areas of Texas, Arizona, and New Mexico, where US policies have pushed migrants to having access to entry into the United States only through those terrains where they are likely to die. Okay, so Honduras, a little bit on Honduras. Well, I should say in Mexico, the problem of disappearances in Mexico is not, of course, just migrants, but Mexicans. And many NGOs across Mexico are focused on the demands of Mexican families of their loved ones' disappearances. So the phenomenon has a double problem: migrants on top of Mexican nationals going missing, disappearing. Honduras, in only about 5 months, from March 2019 to August 2019, an estimated 741 Honduran Mexicans were reported missing. And of course, that estimate does not have anything to do with the vast number of cases that are unreported or were reported but not registered by the government. One thing to know about Honduras is that 1 in 8 Hondurans is migrating out of the country because of the conditions in Honduras. And there are a lot of factors that are causing this out migration. But one of the consequences of that huge proportion of Hondurans leaving the country is that the Honduran government is receiving the benefits of massive remittances, money coming back from expatriate Hondurans. And so the Honduran government does not have an incentive to stop out migration. So there is a tension between the pressure from the United States on Honduras not to allow more Hondurans to leave, and the incentive of the Honduran government to allow its nationals to leave. And of course, from the perspective of human rights, everyone has the right to leave their country. Freedom of movement is a guaranteed right under international human rights law. So why should a government be forced to violate fundamental human rights and prevent its people from leaving? That's anyway our perspective. So as I mentioned, Honduras is a party to the International Convention on Disappearances. It is a party to the Migrant Workers Convention. It is a party to the American Convention and the American Convention on Disappearances. So Honduras, at least on paper, is required to comply with all of these treaties. And this combination of obligations means investigations of all disappearances, prosecutions of those responsible, repatriation in respectful way. And Honduras is, of course, subject to the jurisdiction of the Inter-American Court. And the Velázquez-Rodriguez case, the very first case out of the Inter-American Court, was about enforced disappearances in Honduras. So Honduras has a long history of internal disappearances and external disappearances in which the state itself has been found complicit. And so Honduras has passed some domestic law, but its civil and penal codes are very weak in incorporating definitions that trigger state responsibility to immediately conduct investigations of disappearances. And even though Honduras has this long history of disappearances, it defines a person who is disappeared as absent, which does not invoke the same responsibilities as the definition of disappeared. It does have a definition of enforced disappearances, but it is not the equivalent of the international definition and doesn't impose the most severe penalties on state officials who are part of the disappearance itself. So let me move to El Salvador. Since 2013, the state's Ministry of Foreign Affairs has received 786 reports of Salvadorans missing abroad. And as of April 2020, the Argentinian forensics team has listed 343 missing migrants from El Salvador in its database. Now, El Salvador has also international obligations under many of these treaties that I've mentioned, and has some of the same obligations as Honduras. But El Salvador does not have a specific national law that addresses migrant disappearances. Its constitution, and it does have a special law for Salvadoran migrants and their families. They have some minimal provisions, and it does incorporate the right to migrate, the right to physical and moral integrity, and the right to petition the government, of course, the amparo. In 2011, El Salvador passed a special law for migrants, and this law promises to coordinate efforts to benefit Salvadoran migrants with other countries, neighboring countries, and to assist migrants and their families within El Salvador and abroad. But so far, the migrants' families tell us that El Salvador has almost no cooperation with the neighboring states, and especially with Mexico. And the Salvadoran authorities take the position that once they identify the foreign government that a migrant has gone missing, they believe that their jurisdiction has ended and their responsibility has ended. So that is a major gap in what the migrants' families say is needed to effectuate the Mexican Ley de Víctimas and the MAE. Another issue about El Salvador is that El Salvador has long-standing internal missing persons, disappeared persons. The Salvadoran police told us that they have over 3,000 open cases since the Civil War of disappeared Salvadorans within the country. So they have enormous pressure on their authorities to focus first on the internal disappearances, and they have not been turning their attention to the external Salvadoran migrant disappearances. Guatemala, as you may know, a couple of the most famous cases this year is the 10-year anniversary of the disappearances of the migrants found in mass graves in Ayotzinapa, and 2 sets of mass graves, and the majority of the people found in those mass graves in Tamaulipas were Guatemalan migrants. So there has been, although the families have lodged complaints and asked for answers, still 10 years on, the families tell us there have been no answers for them, for the remains found in those mass graves. And by the way, those were horrible findings. clearly people were burned, the bodies were burned, and so it's quite amazing that the DNA was able to identify who the individuals were. So though migrant disappearances are an ongoing issue in Guatemala, and the government is very aware of it, the number is unknown, data keeping is very inefficient, and so we have a problem with getting estimates. Collecting data has been a challenge for the Guatemalan government, and of course the DNA matching, testing, and DNA preservation is a big challenge for the Guatemalan government. Again, Guatemala is a party to these main treaties and has the legal obligations under these treaties, its constitution, its domestic penal code, and it has a law since 2016, the law for the search of disappeared women, and its migration code have some additional new obligations to protect migrants and their families, and they are also focused on women migrants who suffer additional and enormous harm and abuse en route to their destinations. But the penal code doesn't explicitly address disappearances. The focus has been on prosecutions for kidnapping and for penalizing, and for penalizing criminal gangs and groups. But rather than focusing on coyotes, who tend not to be the abusers, from what the research has found, they tend not to be the abusers for the most part or the cause of disappearances. So the focus on cracking down on individuals who families pay to take their family members safely across the migrant route, from our perspective, that is a misguided approach to what is needed in terms of the prosecutions. And across all of these countries, a major problem is corrupt officials and the involvement of state actors in criminal gangs that are part of the problem of disappearances. Another major problem has been the reasons, the root causes for why people are leaving and why they feel they are forced out of their home countries. And I'll just give you one example: the growth of the maquiladora economy, especially in Honduras, as a result of the NAFTA and CAFTA agreements. One of the consequences of those agreements is that countries have expanded their maquila economies, but are paying people less than a living wage, less than, and subjecting them to conditions of work that don't meet their own labor codes. And so we find deteriorating conditions of work that are forcing people, and particularly women who work in maquilas. This is especially true in San Pedro Sula in Honduras, which is just a maquila economy now. And the very high concentration of women working in these maquiladora factories on behalf of international corporations who cannot make a living wage and who are being subjected to very dangerous conditions. And a high percentage of them are feeling that in order to sustain their families, they must leave the country. So I'll stop there. I've taken up almost all the time, but maybe we have a few minutes for some questions.
Yes, Susan? Hello, and good morning. I have a question. I'm studying law right now, and I'm interested in the human rights. My question is, what I need. What I need to study. Do I need a background or working on something? Yes, that's my question.
Yes, well, human rights is an enormous field. So one of the challenges for you is deciding what aspect of human rights you want to work in. I'm biased towards the human rights of migrants and the forcibly displaced, but human rights involves so many areas of practice: women's rights, business and human rights, which is a growing field and a very important field, rights of indigenous communities, also a very important field in the Americas, international criminal law, which is another field in and of itself, international humanitarian law, that is the protection of civilians in armed conflict. So one of the early things you have to think about is, which area do I want to specialize in? Because the courses that you take are going to depend on which area you want to work in. One of the things I always recommend is try to get some practical experience as early as you can, so that you can see whether you like that area and whether that's an area you really want to go into. So sort of, there's a lot to talk about on this, but that's kind of the general advice that I would give.
Thank you, Susan. And if I may interfere, and thank you so much. It has been incredibly interesting and rich, and we can see your commitment to human rights that we all clap and want to follow. But Nubia, if you were asking about what would make you or any of our friends from this group and beyond a good candidate to come to study law in the US, let me start by saying that yes, yes, yes. Second, if you start working, volunteering now to help us translate, to participate in clinics, to attend conferences, to write articles in English, then that will make you a fantastic candidate, perhaps even to go to the Supreme Court. I mean, I had the pleasure of meeting Judge Sotomayor, una mexicana increíble, and she is at the Supreme Court, and she is the first, but she will not be the last one. Now, Susan always needs help, and Susan has been incredibly helpful and open to UNAM students. So just volunteer. And this Invierno Puma is just the beginning of a path to come to BU or to Boston College or Harvard Law, depending on what you want. And even if, for example, people who may be interested also in copyright law is another very interesting subject with wonderful colleagues at BU, that the copyright laws are different in each country, and it's a complete challenging opportunity for creative, bilingual, trilingual law experts.
I just want to add one note to that, which is that being bilingual in English and Spanish is gold. I mean, I choose among my students, I choose the bilingual students because I know we are going to have seamless work with them, with our Central and Latin American partners. And in terms of so many issues, we are all in this together. We need to work across the Americas to strengthen our collaborations. I never work without partnerships. Our partners are so critical to making this work effective. And there is no way that any of us can do this alone. This is a massive, human rights is a massive project and a massive challenge in the Americas. So, bienvenidos.
Además, Susan habla muy bien español y varios otros idiomas. And why is this important? Because, I mean, we now are receiving through Mexico people from India, from Africa, from the Middle East, not only Central and South America. So, Haiti, if you are fluent in Arab, in French, in other languages, it will just be a treasure trove, and it will usher you into any law school.
Absolutely. Absolutely.
Thank you very much.
It's
Sí se
very
puede.
exciting to have you all interested in this. It's very, very exciting.
Well, so Susan, we don't want to take any more of your time. Thank you so much. This
Mucho
has been
gusto.
incredibly generous, como siempre. Mil gracias y seguiremos trabajando juntos. Have a
Adiós
great
a
weekend.
todos. Muchísimas gracias.